It is an interesting development. The referendum is still a long way from becoming a reality, of course. The Scottish Government don't have the legal right to hold one, and we don't know how they plan to overcome what could be a fairly substantial hurdle. So, who do they have to convince? Westminster or the courts? Well, Professor Ciaran Martin was the civil servant who handled these matters for the UK government, paving the way for the last referendum back in 2014. These days he works at the University of Oxford. Good evening, Professor Martin. Thanks very much indeed for being with us tonight. So, to that question first then, how is this deadlock broken if it is to be broken? Who holds the key, the courts or the politicians?
The politicians. In my view, the fundamental difference between now and a decade ago is then the UK government was willing not just to concede a referendum, but more importantly to contemplate the breakup of the UK should the referendum be won by the yes side. We're now in a completely different situation. I think people forget, and often we talk about as if the objective of the Scottish Government was to hold a referendum. It's not. The objective is independence. A referendum is just a means to get there. And the sort of independence the Scottish Government wants, which is the only sensible and smooth way, is negotiated independence facilitated by the UK Government. And for as long as the UK Government is implacably opposed to facilitating any move towards Scottish independence, which is its current position, saying not now and not for a long time, then legally and constitutionally there's no amount of clever drafting or clever procedural manoeuvres that the UK government, in my view, and in the view of many constitutional experts, cannot block.
So all the focus that's on the courts at the moment, this fight is going to end up in the Supreme Court and that's going to be the ultimate battleground. Do you disagree with that?
Well, it will be a battleground, but there are all sorts of scenarios and we'll have to wait and see which one becomes the reality. But let's say, for example, there is no agreement and there won't be on a so-called Section 30 order, which is the way it worked a decade ago, and the Scottish Government proceeds with its own bill. Two things can happen. One is the Supreme Court blocks it, in which case it is unlawful to have the referendum. The other thing is, and there's a lot of speculation that this is the Scottish Government's plan, there is a slightly weaker form of words, and it's about consulting the people to give the Scottish Government a mandate. Now that might get through, it might not. But if it gets through, it doesn't necessarily end there. The UK government would be perfectly entitled, with its parliamentary majority, to put in legislation to say, no, that's now unlawful. And that would overturn the court's decision. The UK government and the unionist parties could say, we're not going to take part. And crucially, they could refuse to say what David Cameron said in 2011, 2012, and in the run-up to 2014. They could say, we don't care what the result of this sham referendum is, we're not going to facilitate independence. That's what the Spanish did in Catalonia a few years ago. The Catalan government organised a referendum. Spain said, we don't care what the outcome is, and they faced it down. So in a sense, that is why there's no court that can compel the United Kingdom to dissolve itself, no matter what happens. So even if, and in my view it's unlikely, even if the Scottish Government managed to win a court case, that's not the end of the UK Government's options to block independence. Except
Nicola Sturgeon's position on this is that actually the court of public opinion is probably as strong as any other court, in that but Boris Johnson's continued determination that he will block this just isn't sustainable. They've been using the word despot, some members of the Scottish Government, about him if he continues to adopt that strategy. Do you think, from your position right at the heart of these things back in 2014, that they're right, that actually just keeping on saying no, if there's a real head of steam behind this in Scotland, is sustainable or unsustainable?
Well, that's the difference between politics and law, and the First Minister has a perfectly reasonable political point. Anyone who followed the 2021 election knows that the referendum was hardly a quiet issue, and to those who say that the people of Scotland don't want a referendum, well, they had plenty of options to vote for alternatives a year ago. But the hard legal fact is that the UK government doesn't have to be, can't be compelled to do this. So maybe electoral pressure will be brought to bear, but it can be faced down, and over what time frame it can be brought to bear is a matter of politics. And that's why this has to be sorted out by politicians and not by the courts. I think it is of profound importance because, particularly recently, we've always been sort of told to understand the United Kingdom as a union of consent rather than one held together by law. But at the minute, the UK government strategy is to hold the United Kingdom together by law and to refuse to set out any path to referendum and any path to independence. Whether that's sustainable in the long run, that's a matter of politics, not law.
Well, we shall see. We are on the road, it seems, after that statement yesterday. It may well be a long one. Professor Ciaran Martin, thank you very much indeed for your time with us this evening on The Night.
Thank you.